Hello everybody. Good morning to you all. How are you all? I am your friend Mithilesh Jha once again on your favorite legal YouTube channel, Legally Talking. One should say legally talking means legally talking. Today, I shall be dealing with a very important topic which relates to every mankind, which relates to the highest fora of highest court of the nation. Yes, you have rightly guessed. I am talking about Curative Petition. Definitely you must have heard the name of Curative Petition. If you are a student of law, it is a topic must for you. If you are a practicing lawyer in any court, then you must have a gross understanding of Curative Petition. If you are a practicing lawyer at Supreme Court, this is a definite subject for you. And if you are an advocate on the court, it is a must-know subject. So kindly devote your time to listen me carefully. I shall be discussing A to Z of the Curative Petition in a very, very lucid language, so that the terms Curative Petition is made easy to understand every segment of people. Historically, if we see, it may be said that it has a genesis on the basis of philosophy of the foundation of Honorable Apex Court, that is Supreme Court of India, where it is said, Jato Dharma Tato Jaya. Similarly, in case if you realize, the pyramid of judicial system is based on the philosophy that whole system or a part of it, or the pyramid of it, or the stair of it are fallible. So fallibility of the system gives rise to another higher ladder in the hierarchy. And with that concept, we have a different hierarchy of the court in the nation, which starts from the Court of Judicial Magistrate First Class, moving to the Supreme Court of India. And it is presumed that none of us are infallible. Now question arises that once it is an admitted fact that none of us, no member of the system is supposed to be infallible, then how the Supreme Court or the judges of the Supreme Court shall be infallible? That was a question haunting the mind of legal luminaries, judges of the highest court. It had been drawing the attention of great stalwarts of the subject and faculty. Now, again, if we remember, besides Jato Dharma Tato Jaya, the philosophy behind ubi jus, ubi remedium, where there is a right, there is a remedies. Also the philosophy behind truth alone triumph, meaning thereby Satyamev Jayate. These are the few terminology which essentially gives birth to the foundation of curative jurisdiction of the Supreme Court. Now, question arises how basically this particular jurisdiction has developed. It is said that normally it had its origin from the case Rupa Ashok Huda versus Ashok Huda. I shall not be going to the details of that case so as to have the brief video, but again it stuck to my mind that is it the beginning? Whether Rupa Ashok Huda was really a beginning for the curative petition. In my opinion, as a student of law, as a practicing lawyer at the Supreme Court, as an advocate on the record in the Supreme Court of India, I personally feel not exactly that. No. Rupa Ashok Huda was a flagging ship from which a green signal was given by Justice Bharucha. Historically, in case if we happen to move, we can recollect some of the stories, some of the important events in the legal system. And in case if you recapitulate, you'll find the case of A.R. Antule versus R.S. Nayak. Briefly, in which you remember that jurisdiction of trial court was given to the High Court, and that was the controversy before the Supreme Court, that whether the Supreme Court has such power where High Court can function the court of a designated court of a special jurisdiction which had been notified by the legislation. There was a controversy, there was a difference of opinion among the judges. Some of the judges, when it was adjudicated with the division of 3:2, meaning thereby two judges were of the opinion that no, we cannot hear this particular question, especially in review jurisdiction. But again, the bigger question was, there was an admitted fact that Honorable Apex Court had committed some error. There was also an admitted fact that they recognized that error had been committed and that needed ramification. But unfortunately, the Honorable Apex Court had no jurisdiction to deal with such situation. So that was the beginning. Controversy and brainstorming started from that point. History kept on moving. It was almost a similar story when the case of B.J.S. Mishra versus SCBA, in which Mr. Mishra was the president of Allahabad High Court Advocacy Lawyers Association, and Honorable Apex Court had cancelled his license. SCBA agitated this issue before the Honorable Apex Court, and it was once again held that Honorable Apex Court had no such power. Honorable Apex Court could have not cancelled the license of Binay Chandra Mishra. It was held by Honorable Apex Court that under the jurisdiction of contempt jurisdiction provided under Article 129 and 215 or otherwise provided in the Contempt of Court Act, The Honorable Apex Court or the High Court is entitled to prescribe the punishment only which had been mentioned in the court, that is 6 months of punishment or 2,000 rupees or both, and nothing more. Anything else which has been mentioned under the Advocate Act, especially in section 30, those powers vest with the Bar Council of India and not with the either with the Supreme Court or with the High Court. Again, the fallibility of the Honorable Apex Court was recognized. Then again, a very, very brainstorming, very, very serious deliberation were undertaken by the eminent jurist, which included the judges of the Honorable Apex Court. This brainstorming was on, and ultimately it was Justice Bharucha who took a call that we shall be going to develop a special jurisdiction for the Honorable Apex Court, which shall deal a situation where nobody can say that his cause was not heard. And fallibility, they have realized that in case judges of the Honorable Apex Court commit some error, then what could be the fate of the nation and what could be the fate of the citizen who suffered at the hand of the judges for his ignorance. And that was a founding stone giving about to Curative Petition, and ultimately a special jurisdiction was developed in Rupa Ashok Huda versus Ashok Huda in 2002, and since then we have the jurisdiction of Curative in the side of Supreme Court. It has certain special procedures. It can be set. This is a review of review. This gives an extra opportunity, and in case if we happen to analyze the recent happening, we could realize and we found this had been very, very useful instrument where judges of the Honorable Apex Court had not taken any bad call. Judges of the Honorable Apex Court had always been serious to think that in case they have committed some errors, and some errors are manifested either on record or from the fact, then they are always ready to ramify those without any reservation and without any egos hurting them. Recent judgment of Delhi Metro Corporation and Airport Metro had been very important, in which review petition was dismissed, but Honorable Supreme Court has allowed the curative petition. Furthermore, I shall be discussing in next video. Till such time, I take a goodbye. Thank you so much.